supplementary. Clerk.
To ask the Minister of Justice what action she intends to take following the High Court decision on the Justice Sexual Offences and Trafficking Victims Act, Northern Ireland 2022.
The Minister for Justice.
Legal challenges against sections 12 to 16 of the Justice Sexual Offences and Trafficking Victims Act, Northern Ireland 2022, which relate to the anonymity of persons suspected of a sexual offence, were heard in the High Court on the 22nd and 23rd of April, and Mr Justice Humphreys delivered his judgment on the 31st of May. The judgment found in favour of the applicants in respect of the challenge that the provision was incompatible with Article 10 of the European Convention on Human Rights, which is the right to freedom of expression, and declared it unlawful. This was on the basis that the provision criminalised publication of a suspect's details without recognising any public interest offence, and failed to provide for a process by which media organisations may apply to the court during a suspect's lifetime to have the prohibition on publication modified or revoked on public interest grounds. The other grounds of challenge, which related to the retrospective effect of the provision and an alleged lack of procedural fairness, were not upheld. As members will appreciate, I will now wish to take time to study the detail of the judgment in conjunction with my department's legal team before making any decisions on a way forward.
I call Mr O'Toole.
Minister, while the intentions may have been good, it is important to recognise that this has been terrible law. Mr Justice Humphreys, in his judgment, was clear and damning. He said the imposition of a criminal sanction on public interest journalism and the chilling effect occasioned thereby represents an interference with Article 10, which requires the most anxious scrutiny. Given that newspapers are and have over the last weeks and months receiving letters telling them not to report the names of offenders who have deceased offenders who have already been named in civil proceedings, can't you today be clear that you will not attempt to appeal this decision, because any attempt to appeal this decision would, I'm afraid, just double down on bad law and be a waste of public money?
Minister.
Well, as I have already said, this is a complex and detailed legal judgment, and it does not just have implications for this particular piece of legislation, but potentially also for this House. Appeal is therefore always an option. However, I will want to carefully consider all my available options, and in conjunction with the Department's legal team, before arriving at a decision to the best way forward. The judgment goes beyond the reach of solely my department, where it has a wider bearing on future functions of the Assembly. All involved will want to carefully consider whether there is the potential for unintended consequences.
Alistair.
The Minister walked the Assembly into this folly, not least by exaggerating Lord Justice Gillen's proposal. Does she accept the judicial rebuke? And how is she going to retrieve the situation?
Minister.
Mr Speaker, to be clear, I did not walk the Assembly into anything. The Assembly, in fact, scrutinised this legislation, and the Act is an act of this Assembly. The member who has raised the question was in the chamber and indeed raised objection to other elements of the bill, but not to this provision in the bill. I would also correct him in saying that I exaggerated Sir John's position. I have it in writing from Sir John in front of me that it is not true to say that he did not recommend the new law, or that I misled MLAs about his report. He did recommend that measure of anonymity, albeit not the 25 prohibition post-death. The latter point, however, he recognised as entirely consistent with the spirit of his report.
Linda Dillon.
Thank the Minister. Minister, can you give us a guarantee that in your engagement going forward that you will engage with victims of historical clerical abuse, historical institutional abuse, because this law does actually have a massive impact on them, and a number of them have contacted me in relation to it?
As we take this forward, we will be not only engaging in terms of our legal team, in terms of the judgment itself, but we'll also be looking at the import of that in terms of future legislation and any potential change to this law. We do take seriously the issue of victims, indeed one of the reasons why this law was introduced. and was on a par with the anonymity awarded to victims, was to ensure that the right of victims to anonymity could not be undermined by jigsaw identification. So victims' concerns and victims' rights has always had primacy in this conversation and will continue to do so.
Joanne Bunting.
Speaker, this is a very concerning situation which unfortunately has resulted in reputational damage for the Minister, her department and indeed this House. These were significant unintended consequences which were missed despite all our collective procedures, because in the last mandate this institution was rushed and sacrificed quality for quantity. So the questions are, did the officials in the DSO not know the potential ramifications? Did they not understand, or did they mislead? Because whichever way, I'm sure she will agree, this is not a good outcome. Moreover, how will this change the mindset of her department with regard to how it considers and brings legislation? What are the lessons to be learned? And also, I trust that this ruling will cause the Minister and her department to have pause over their custom of bringing policy matters at consideration stage rather than on the face of the bill, when things like this can occur even without that risk.
Minister.
Well, as the Chair has recognised, this didn't happen because it was brought at consideration stage, so the drawing of any conclusions in that regard would not actually follow through in logical terms. I welcome the opportunity to put on record clearly that neither I nor my officials misled this Assembly in any way. Not in any way. We were clear, and I would categorically refute any suggestion that that was the case. The provisions were included in the bill at its introduction, and while it is factually correct that specific queries were not raised about the provisions, it shouldn't be interpreted as misleading the Assembly. The committee did not ask questions on these particular provisions. They were neither hidden, nor was there any failing on my part or that of the department. Where the committee sought clarity and additional information, that clarity and additional information was provided. I also do not accept the member's assertion that legislation was rushed through in the last political mandate. While it was a challenging period for all, no processes were condensed in the committee, and we worked with members, including members of the Justice Committee, to ensure that appropriate time was given for full scrutiny to be applied. There were no condensed passage of any bill. I'm conscious that my officials and I made ourselves available, both at long and short notice, to provide additional information, and I would draw her to the then chair of the committee himself, Mervyn Storey, who said the bill underwent extensive and detailed scrutiny and debate. The committee stage and lengthy debates at consideration stage and further consideration stage resulted in a large number of amendments being made to the bill and the addition of a range of new provisions that have improved and strengthened the legislation to provide protections for some of the most vulnerable, the victims of sexual abuse, child exploitation and human trafficking. That is most welcome. He went on to say the committee did not just scrutinise the provisions of the bill in full and thorough manner, but actively looked at current legislative provision and identified opportunities to improve it and deal with emerging types of offending behaviour.
We move to Stuart Dixon.
Minister, for the answers to the questions so far. Minister, could you tell the House what representations were made by the media during the passage of this bill?
To the best of my knowledge, no representations were made either to the Department or to the Committee as this passed through the House. The first representations that were made in respect of the legislation from the media came at the point where these provisions were commenced, which was a considerable time after the passage of the bill.
Butler.
Thank you, Mr Speaker. I just want to put on record my thanks to the Minister who initially did meet me on resumption of the Assembly for a 45-minute meeting in this, and she recognised that I wanted to bring a private member's bill to achieve what Justice Humphreys actually did on Friday. Minister, we were in disagreement in regard to the victims of historic sexual crime in terms of how they interpreted this, and I enforced on you the removal of hope that Section 12 actually did to them. Would you accept today that victims of these sexual assault and sexual crime now have had that hope restored, and would you recognise that today in terms of moving forward with this?
Minister.
Well, I thank the member for coming to meet me, and we had, I think, a productive and useful discussion. The grounds on which the member objected to these particular sections of the legislation are not those that were tested before the courts and are not relevant to those that were tested before the courts either. Well, there was always obviously a concern with respect, and it's already been raised by other members, with respect to the right of victims to speak about their experience. And that is why the basis on which the restrictions on reporting were drafted were narrowly drafted so that victims could retain their anonymity, but would also have some recourse to be able to speak. But we are now in a different position than when we met, and it will be for me, with my officials and with the legal advice available to us, to look again at these provisions and to look at all options available to us at this point in time.
Deirdre Hargey.
Thank you to the Minister for coming along today, and obviously the High Court has made a decision and a ruling on this matter, and the Minister will know that I had raised concerns in terms of the legal case back in February when we had met, granted that the legal process was still ongoing at that time. But I suppose in the context of that now and in the context of the ruling, just to give clarity to victims and survivors, would you be able to indicate a timeline as to when your next steps can be known? Thank you.
Well, we will be heard again in the courts in terms of the parties to proceedings, in terms of the precise form of declaratory relief, and that will happen shortly. We have 6 weeks in which to reach a conclusion as to whether or not the judgment should be appealed, and we will obviously want to take legal advice speedily on that matter ahead of that deadline to ensure that we consider all of the implications of this ruling, not just for this particular piece of legislation, but more widely for legislation passed by this House.
That concludes. Oh, sorry, Mr. Stone. That concludes questions in the statement. Next item of business is a motion to approve a statutory rule, and ask the clerk to read the motion.